Hello and welcome. You are watching News 9 live. I am Krishna Kumar and I'm being joined by my colleague Ashok Bagaria. And we, over the course of the next 25 minutes, will be discussing all about the no rethink that has been ordered on the sedition law in India. The use and misuse of Section 124A of the Indian Penal Code, IPC, which deals with sedition, has always been a subject of public debate and discourse. But despite many arguments against it, the Law Commission of India strongly backs the sedition law, recommending it even to be retained with changes linked to the circumstances of its use. Also, the Law Commission recommends that the punishment for sedition be increased from 3 years jail term to a life term or up to 7 years of imprisonment. The Law Commission report states that repealing the sedition law altogether can have serious adverse ramifications for the security and integrity of India. Last year, after the former Chief Justice of India, N.V. Ramana, expressed concerns about the misuse of the sedition law, the Government of India had said that it would take a relook at what has been described only as the colonial provision in India's penal code. The government then asked the Law Commission to review the sedition law after it was challenged before the Supreme Court of India. There are many instances of sedition charges being slapped against intellectuals, human rights activists, filmmakers, teachers, students and journalists, of course. Now let's first begin by listening in to what former Additional Solicitor General and Senior Advocate of the Supreme Court, Aman Lekhi, had to say on the matter.
I see absolutely nothing wrong with the recommendation. The general criticism which is made of sedition, of its being of colonial vintage, in my opinion is misapplied, because the law as applied in Tilak's case is not the law of sedition as applied in India to independent India. And what the Supreme Court in Kedarnath follows is in fact not the Privy Council but the Federal Court. And the Federal Court moved away from the enunciation which Tilak's case did. As an offence, sedition goes to security of state, and therefore it's got an integral link with public tranquility and maintenance of order. And any action which leads to overthrow of the government or defiance of its laws necessarily moves into an area of security of state, and the government in that event, in that situation, is obliged to act against offenders who so act. The criticism of its being applied to curb dissent may be justified, but sedition as it's framed and the section as it stands, including the law which has been applied to uphold it, does not permit the movement of the penal provisions of Section 124A into area of political dissent. So where the section has been so misapplied, that's not because there's something intrinsically wrong in the provision, but what is wrong is in the application. Because it is wrong application of the provision of the provisions. The Law Commission has correctly talked about guidelines, which is in fact an acknowledgement of the abuse. As long as the guidelines are there and the check is placed on the misuse to limit the applicability of the provision to offences to which it actually relates, the sustenance of this provision, in my opinion, is extremely necessary and is, I feel, quintessentially necessary for us, particularly considering the environment we are in. And so I will not so much be affected by what the UK did, because it has a different history altogether. And in any case, even in UK, there are laws to deal with such acts too, not necessarily described as laws relating to sedition. But whatever may be the situation, UK or any other states that abolish sedition, the question here is, because we have a statutorily defined section which limits the applicability to uh, rather properly laid out areas. The importance of this particular section to issues of governance cannot in any way be underrated. And so, sustenance of it, maintenance of it, and continuance of it, in my opinion, would be necessary, subject, of course, to the guidelines so as to check its abuse.
Right. Ashok, straight off the bat, I have to ask you, the discussion can swing between two extremes. Let's cut out the extremes first. Is there a need for a sedition law, an idea that was essentially mooted during the colonial era today?
Well, it's my personal opinion that basically sedition law is actually working as an unnecessary impediment on your freedom of speech, the freedom of speech of the citizens of this country. And the other reason why I believe the sedition law should be struck down of the statute book is the fact that, number one, it's misapplied, it's misused, abused by the authorities. The political party which comes to power weaponize this law.
Whichever political party comes to power.
Whichever political party. It's not about BJP, it's not about Congress, it's not about AIADMK, or it's not about any other political party in Jharkhand, because I'll give you instances where these laws have been abused or misused. The third question is, the third reason that I believe that sedition law should be struck down is the fact that the law has been framed or has been put in such an ambiguous manner, or the language of the law is such ambiguous that there can never be a certainty. For the last 75 years, we have been trying to figure out a way as to what really constitutes sedition and what does not constitute sedition.
Right.
So, if a law is so shrouded in ambiguity, it either be struck down or either you simplify it.
Right. And I want to, before we go to the guest, I want to understand your thoughts on the, the Law Commission, the process it went through, because, you have the Supreme Court of India asking the Government of India, and the government asking the Law Commission, and the Law Commission eventually coming back and making a few changes, making the punishments harsher, and also all the changes. I want your view on what do you make of the changes that were made?
Well, as far as the Law Commission is concerned, the Law Commission is basically a recommendatory body. It's an advisory body.
Fair enough.
Their recommendations do not carry any weight. They can be rejected by the Government of India, they can be accepted. So, there is no power behind the recommendation of the Law Commission of India. It's just an advisory body.
But what do you think of the advice it's given?
I think that it's not a measured advice that has been given by the Law Commission. The Law Commission basically says that just because a law is misused, it cannot be a ground of it cannot be a ground for striking it down. Well, that's a correct position, because even in the past the courts have held just because that there is a law which is being misused, you cannot ask for erasing the law because it's been misused. The second thing which I find a little troubling or cause of concern is the Law Commission of India making a positive recommendation and saying that this law on sedition is required to deal with people who have separatist tendencies. Now, as a country, if you look at India, you have militancy in the northeast, you have militancy in Jammu and Kashmir, you have the Naxal movement which spreads to a couple of states.
From central India onwards.
Onwards to the southern India. Then you have people...
There's talk of secession in Tamil Nadu.
Secession in Tamil Nadu. Now, this particular law has been acting as unnecessary fetter on the freedom of speech. If people today speak something against the Prime Minister of the country or the Chief Minister of a particular state, the cops do the first thing is to slap a case of sedition against you, which is extremely funny, weird, and not acceptable.
Yeah. The problem here is, Ashok, like you said, if the Law Commission takes a position that just because a law can be misused doesn't mean you strike it down. And you were telling us, there are more reasons than just that, which make you say that, there is no need for such a law in the first place.
Yeah. So, I'd like to give you a couple of instances. That first, let's take from 2014 to 2022. Now, why do I choose this time period? Is because the National Crime Records Bureau, NCRB, has been maintaining a data of the FIRs which have been registered for sedition. So what we see from 2014 to 2013, 2022, is there is a tremendous rise in the number of sedition cases which have been filed. The highest was sometime in 2019, where as many as 96 cases were filed across the country. Of them, 144 had to go for trial. In 28 cases, there was no evidence. In 58 cases, again, it was found by the court that no offense of sedition is made out. So those cases have been chucked out. The conviction rate is as poor as 3%. Now what happens is that once you are charged with sedition, a person is put to great difficulty in the sense that the moment you are charged with sedition, you are immediately arrested. And getting bail for a sedition charge is very difficult. It's only after you come to the High Court or the Supreme Court that you are able to persuade the court and make out a case of personal liberty and freedom of speech that you are granted bail. So the
although it is not a non-bailable case, it is a bailable case at the end of the day, but actually obtaining that bail is extremely difficult.
Extremely difficult. The second problem for the person who's faced with the charge of sedition is that he or she faces great difficulties in getting a passport or a visa, because that, if you look at the offense, it's basically an offense against the state. So the state will come down heavily on you, saying that, oh, you have a FIR of sedition against you, so possibly I need to take a relook at your passport or visa application, and that could be one of the grounds for rejecting your visa or passport, which has happened in the past. I was talking about the fact that how BJP, Congress, DMK, AIDMK, or any other shade of governments have misused this law in the past. Now, I'll give you the case of Tamil Nadu, for example. There was large-scale protests in Kudankulam against the nuclear power project coming up. 10,000 people were charged for sedition. 10,000 people. 4 or 5 villages en masse, they were booked for the charges of sedition. This is Tamil Nadu. Let's come to Jharkhand. There was Pathalgadi protests which were happening by the tribals. 7,000 people booked for sedition. What is this?
Incredible. We have Mr. K.C. Mittal, constitutional expert, now joining us on this broadcast. Mr. K.C. Mittal, look at these cases. Kudankulam, 10,000 cases of sedition charged on protesters. Jharkhand, Pathalgudi, 7,000 cases of sedition charged against protesters, essentially. This law is being misused at an incredibly huge proportions, and hence that simple argument that just because a law gets misused doesn't mean it can't be struck down does not hold in this particular case. Would you agree?
I substantially agree with Mr. Ashok and the way he has highlighted the whole issue. Let me just add few things to you. Misuse is one thing. And unfortunately, in this country, what we are noticing is you bring a law, before the law is enacted and put in force, the misuse process starts. This is what you pick up any subject. We see notice every day in the courts. Every law is being misused. Quota was being misused. Mokoka, of course. Then you see ED, TMLA, which is not being misused. It is there. Let's go to another fundamental issue. See, when was this law enacted? This was put in force to suppress the freedom of struggle. That was a totally different environment, and the government had brought in this law purposely to suppress the freedom of struggle. Today, that is not the situation. Why do we need this law at all? See, and that's where the Supreme Court has also taken note of it. That's why 3-judge bench has put it in abeyance. Let me tell you 3-4 important aspects. And Mr. Lekhi also pointed out one. It should not be to curb the political dissent. That's one important aspect. It should not have chilling effect on the freedom of expression, which it has nowadays. Law Commission says enhance the punishment, you are making it more draconian. How can you have it? The existing law itself is not required in the given situation. Today, this colonial system, the law must be either repealed or, if at all, it should be used only in grave position available situations that might arise. What is happening today? You can't just put anybody and everybody behind bars and use this law. This is what is happening in UAPA also. People are just put behind the bars and there is no remedy available to them. They don't even get bail. The purpose is not that. The purpose is, in a genuine case, if there is anything one can understand. And I think my friend Ashok has rightly pointed out and given some instances. The whole aspect has to be seen from a different uh, perspective. What the three-judge bench of the Supreme Court has observed while putting the law in abeyance, and I think ultimately the Supreme Court is going to strike a balance, maybe, because that's what the one can read the order of the Supreme
All right,
Court where it,
fair enough, fair enough. Casey Mittal, let me just check with Ashok Bagaria on that as well. Ashok, do you think that the Supreme Court would eventually strike the balance? Because at the end of the day, you're talking about a law that has no business being there in the first place, you know, according to many, and now you have a situation where that law is being made harsher, if it's possible.
It's very difficult to say that which way the Supreme Court will rule. But the Supreme Court of India as an institution has made prima facie observations on this law. First, it was the former Chief Justice of India, Justice N.V. Ramanna, who made very strong observations about this law, saying that even gamblers, people who play cards in villages, have been booked for sedition. So, and he also went on to say that this is a law which was used to imprison our freedom fighters like Gandhiji and Tilak. Why do we need a law like this in today's time? Then we have the present Chief Justice of India, Justice D.Y. Chandrachud, who also, while hearing another bunch of petitions with respect to sedition, he says, yes, I believe that it is time we redraw the boundaries of this sedition law and determine what actually sedition is and what is not sedition. It's time we need to redefine or rework around it. Either we scrap the law, we strike down the law of the statute book, or there has to be some reading down of the existing proviso which exists. So there will be a very hard task in front of the central government to defend the law. They will have to convince the Supreme Court of India that there is no need to read it down, nor is there any need to scrap it off the statute book. And for that matter, the Law Commission report will come in handy for the central government, where the central government will tell the Supreme Court that, you know, we have a recommendation from the Law Commission of India which says that just because this law is being misused, it cannot be a ground for scrapping it. Now, coming to what Mr. Mittal said a little while ago, I just want to add two things to it. That number one, that definitely sedition is a colonial era law. So is the Indian Penal Code, which deals with all the offences that that are recognized in this country today. But you have to see that the country which introduced this law of sedition has purged the law itself. That is Great Britain. England has done away with the law of sedition. They have said that we don't want an offence like sedition on our statute book. And what we have today as sedition was directly borrowed from the English lawmakers. The other thing is our neighbours, Pakistan. A couple of months back, the Lahore High Court struck down sedition law in Pakistan. Now it's time. India should try to take cue not only from England but even from our neighbour Pakistan and do a rethink around it. It's high time that this law, which is primarily acting as an unnecessary curb on freedom of speech it's time to do away with it.
Right. Now, as we wrap up this particular discussion, let's now listen in to what former Law Minister and Senior Advocate Kapil Sibal has to say on the sedition law being misused.
Recently, the Law Commission of India has recommended a stricter regime in the applicability of the sedition law. Contrary to the observations of the Supreme Court, that this is a colonial law, it has served its purpose during the times of the British, and in that context suspended further FIRs to be lodged. You must understand that conceptually the Law Commission has really not understood as to why the Supreme Court said that. There is in law the concept of the government and the concept of the state. Sedition law in colonial times dealt with agitations against the government of the day, not with reference to activities against the state. So any agitation against the government would result in filing a case under the sedition law, 124A of the Penal Code, whether it was against Gandhi ji or it's against all the national leaders. कोई भी सत्याग्रह होता था तो sedition laws पे लागू किया जाता था, क्योंकि वो सरकार के खिलाफ होता था. Then we became a republic. The republic represents the state. The government doesn't represent the state. Therefore, this sedition law has lost its relevance because we have a fundamental right under Article 19 to protest against the government. But we don't have a fundamental right to destabilize the state. 124A of the Penal Code deals with agitations against the government, which is part of our fundamental right under Article 19(1)(a). The UAPA, for example, is a law that prevents activities against the state. So if you incite violence against the state, you'll be prosecuted under UAPA. If you incite disorder that results in violence against the state, you will be prosecuted under UAPA. But if people are sitting on dharna and the police officers comes to the conclusion that this has a tendency to incite violence, you will be prosecuted under the sedition law. Any dharna, any satyagraha, any agitation, farmers' agitation, women wrestlers' agitation. And see what the law says. The expression tendency means mere inclination to incite violence, forget that, or cause public disorder. So any tendency to cause public disorder may result in life imprisonment. I mean, has the Law Commission been commissioned to do this? Has the Law Commission been commissioned to make such a proposal, to try and strengthen the hands of the government? I am shocked that the Law Commission does not itself understand the difference between government threat, public disorder in the context of agitation against the government and public disorder in the context of agitation against the state. That is dealt with under the Code of Criminal Procedure. This is dealt under sedition. And even the Law Commission does not understand that difference. I am absolutely amazed. That's number one. So therefore there is complete conceptual confusion. इनको ये नहीं मालूम कि सरकार और स्टेट का अंतर क्या है. कभी लॉ कमीशन की रिकमेंडेशन जो राइट अप मेरे पास है, कभी वो सरकार की बात करते हैं, कभी वो स्टेट की बात करते हैं. इतना नहीं समझ कि जो अगर सरकार के खिलाफ जो कोई भी एजिटेशन होती है, वो एजिटेटर्स का हक है आर्टिकल 19 के अंतर्गत. विदाउट एजिटेशन सरकार तो वैसे भी नहीं सुनती. एटलीस्ट एजिटेशन के द्वारा बात जनता तक तो पहुंचती है. सरकार ना सुने लेकिन जनता तक तो पहुंचती है. और अगर आप ये डर पैदा कर दो लोगों के मन में कि अगर हम सड़कों पे जाएंगे, प्राइस राइज पे एजिटेट करेंगे या फार्मर्स एजिटेशन करेंगे तो हमें उम्र कैद हो सकती है, तो निश्चित रूप यही मानसिकता है सरकार की कि सारी एजिटेशन बंद करो, भय फैलाओ लोगों के मन में, ताकि वो सड़क पे आ ही नहीं. उन्होंने कहा है कि ये भी एक सुझाव दिया है कि 154 धारा 154 IPC के अंतर्गत under section 154 of the IPC, you can put in a provision that there should be a preliminary inquiry. There may be a preliminary inquiry before you proceed against a particular individual under the sedition law. But preliminary inquiry तो CBI भी करती है. वो क्या है आप देख लीजिए CBI में होता क्या है. मतलब कि एक कानून, ये कानून और ऐसे कानून हथियार बन गए हैं. दे हैव बिकम इंस्ट्रूमेंट्स ऑफ ऑपरेशन. सरकार के हाथ में हथियार देना ताकि आम जनता कि अगर कोई जनता एजिटेट करना चाहती है, अपनी मांगे रखना चाहती है, उसकी भी जुबान बंद कर दो. साइलेंस हिम. कहने का मतलब ये है कि I am disturbed at the recommendations made. These recommendations themselves are contrary to the ethos of the Republic. They are contrary to the very essence of the Republic. They are contrary to the foundations of the Republic. They give the status, they have given status of the government as if the government is the state. Government is installed through the will of the people. It doesn't represent the state. It works for the state. Conceptually, this is a law which is conceptually flawed. Let me tell you another thing, कि 2014 के बाद लगभग 10,000 से ज़्यादा केसेस सेडिशन के रजिस्टर हुए हैं और सेडिशन के द्वारा कार्रवाई हो रही है. उसमें से मेरे ख्याल 329 लोगों की कन्विक्शन हुई है. अब इसमें कई मैटर्स में कार्रवाई चल रही होगी, चार्जशीट अभी फाइल नहीं होगी, लेकिन कुछ आंकड़े बताते हैं कि कन्विक्शन रेट लगभग 7.5% रहा है. तो आप सरकार के खिलाफ कोई एजिटेट करना चाहे, उसकी ज़ुबान बंद करना चाहते हो और सरकार को ऐसा हथियार देना चाहते हो कि जो भी बचा खुचा है इस देश में रिपब्लिक का, वो भी ख़त्म हो जाए.